Good morning, ladies and gentlemen. I'm very pleased to have had the opportunity to have been invited to participate in this conference, and I hope you'll find this presentation of some interest. Of course, you'll see that the title on the first slide isn't what the moderator said it would be, because when it comes to competition law, at all times you are dealing with the real world and real world situations. So I'm here to speak with you about some recent developments in the case law of the European courts. But these recent developments and litigation in general doesn't fall out of the sky. It's something which is based on actual facts. So I've titled this presentation of Cattle, Car Crashes and Cards, because that's the background in respect of which each of these cases has arisen. The topic I'm dealing with, fundamentally, is restrictions by object. And one might ask, why a presentation on restrictions by object? There are three reasons why I chose this topic. The first is because this topic has very important practical consequences for lawyers, for academics, and for those who are required to enforce competition law in the member states. Because the rule that says that a restriction, that an agreement or arrangement can constitute a restriction by object, in effect shifts the evidential burden away from onto the party who is alleged to have committed, to be engaged in the anti-competitive activity. If a competition authority, or as in our system, a plaintiff, wishes to show that an arrangement between undertakings has anti-competitive effects, the onus of proof is on that party to demonstrate on the balance of probabilities that the activity in question has such effects. But when one is faced with a restriction by object, it is possible for the competition authority or the plaintiff to simply demonstrate that as a matter of principle, the arrangement in question is anti-competitive. And then the onus of proof shifts on the parties that are engaged in the undertaking or activity to show that that is not in fact the case. So it is a very important instrument in the practical application of competition law. Second, there has been a renewed interest in this particular topic because, as you are probably aware, in 2003, new regulation came into force whereby, in effect, the enforcement of competition rules at the community level was devolved away from the competition onto national competition authorities and indeed towards a form of self-assessment on the part of undertakings and their advisors. Prior to that time, you had a system effectively of block exemptions. And block exemptions clearly prohibited what we would call restrictions by object. They were simply prohibited. And it was then there was no debate as to what constituted a restriction by object. But of course, when the system is opened up, you have restriction by object, the definition of which then becomes an issue, as we will see from the cases which we will look at this morning. And finally, the reason why I chose this topic is because last month the Court of Justice delivered judgment in the third of the cases I'm going to refer to, which, in my view, clarifies the law considerably and restates the law, which had become somewhat confused as a consequence of the second case, the car crash case, which seemed to have been more of a car crash perhaps than a case which I'm not going to go into detail on, but I'll explain that later. So let's have a look. Oh yes, first of all, cattle. We've plenty of those in Ireland, and that's a fine example of one of them. In Ireland, traditionally, we feed cattle on grass. This means that the cattle come to market in the autumn. This meant that in order to slaughter the cattle, because we export 90% of the beef we produce, the slaughterhouses had to have capacity to deal with the demand in those 3 months. So we had effectively 30% overcapacity in the beef processing market. And as a result of the Common Agricultural Policy, farmers were given incentives to produce cattle all year round. In other words, to reorganize their affairs so as to put animals on the market on a more regular basis. So we ended up with this overcapacity. And what happened was that the government decided that in the national interest, we should reduce the number of processors on the market from about 20 to 4 to 6. A number of reports were produced, and a scheme was come up with whereby the 4 or 6 producers who would stay on the market, they're called the stayers, was a levy on the animals they would slaughter. That levy would be paid to an organisation called BIDS, the Beef Industry Development Society. And that money in turn that BIDS collected would be paid as compensation to the processors who left the market, compensation for leaving the market. The way this was to be done was that the stayers would pay €2 per head of what was called their traditional kill volume. So that meant as long as they kept killing the same number of cattle as normal, they had to pay €2 per head. But if they went above their traditional kill volume, and this was an aspect which, apart from the inherent difficulties with the project, this was a side aspect at the same time. If any stayer increased its production, they had to pay a levy of €11 per head of cattle killed above their traditional kill volume. The goers were to receive financial compensation, and the compensation was on condition that they decommissioned their plant. The land on which the plant had been situated was not to be used for beef processing for 5 years, and there was a non-compete clause with the stayers for 2 years, so they could come back into the market after 2 years, but they couldn't use the same land. That, of course, would be a major constraint in the Irish context. They would have to buy new land and set up new factories elsewhere, which meant the practical reality was they would stay out of the market. There was litigation before the Irish courts, and in fact it's somewhat unusual because compared with other EU member states, our competition authority does not have the power to impose fines or prohibit arrangements between parties. If our competition authority wishes to require undertakings to do something or wishes to fine them, it must bring proceedings before the Irish High Court. The Irish High Court then has the authority to impose those fines or prohibit the activities in question. This litigation took approximately 3 years before our High Court, and the High Court ultimately ruled that the arrangements in question were not restrictions by object, but if they had been restrictions by object, they would not have qualified for exemption under Article 81(3) of the EC Treaty as it then was. The matter was appealed to the Supreme Court, and a reference for preliminary ruling was made by the Supreme Court before hearing argument from the parties, just on the basis of what had been argued in the High Court. The matter then came before the court, and the court gave judgment, and you'll see that the question is what test was to be applied. The object is to be determined after considering the precise purpose of the agreement in the economic context in which it is to be applied. In other words, you look at the agreement itself, and you look at the context in which it's applied. And if we come on to that in somewhat greater detail, the precise purpose is ascertained by examining the text of the agreement and deriving from that text the objective it seeks to attain. So you look at the arrangements between the parties, and on that objective basis you determine what objective does the agreement seek to attain. You're not looking at the subjective intentions of the parties, and we'll see that later on when looking at the other cases. The economic context is ascertained from an objective overview of all relevant contextual elements. That's, first of all, it must be objective, and secondly, you look at all relevant contextual elements, not some. you're not limited to looking at, for example, effects on a particular downstream market or defining a relevant market in certain circumstances. The court found that the bids arrangements intended to improve the overall profitability, these are the agreements themselves, of the undertaking supplying over 90% of the beef processing services by enabling them to approach a minimum efficient scale. And they were going to achieve that aim, which was ascertained from the arrangements themselves, not from any outside evidence, by reducing significantly the number of suppliers, thereby eliminating 75% of excess capacity. I think it's important to point out that the facts of the bids case were relatively straightforward, relatively simple, notwithstanding the fact that it took the High Court 3 years, and when that's partly to do with the litigation process in Ireland, but the hearing itself took in the region of around about 30 to 40 days hearing of evidence. The case was relatively straightforward at its heart, and it allowed the court, in a relatively short judgment, to make a fairly clear statement of the law. Of course, circumstances moved on, and we will see that the next case that I'm going to look at briefly is the Allianz case. Now, I don't propose to go into this in any detail for a very simple reason. First of all, Dr. Nodge is going to speak about this case in somewhat greater detail, and I suspect that he will have his views on this are not so removed from mine that require me to bore you by repeating the two cases. What I will simply say is that, first of all, it involved a far more complex situation. The factual background was not as straightforward because you were dealing with a situation in which the motor traders were in fact acting in two different capacities in their dealings with the motor insurers. I'll say no more than that. Obviously, a far more complex situation than that which pertained in relation to an arrangement between beef producers to mutually reduce production in order to reduce capacity by allowing or encouraging or paying some of their members to leave the market. So it was a more complex situation. And secondly, the other reason why is because while the Advocate General's opinion was relatively straightforward and seemed to keep within the bounds of what had been decided in the bids case, in the Allianz case, the court's decision, let us say, was not perhaps quite as clear as it ought to have been. Nonetheless, you are probably familiar with the usual way in which courts behave. It's very rare that a court will say its previous judgment is wrong unless it has to. So Allianz still remains as, in principle, good law. However, I would suggest to you that the utility of the Allianz judgment in reality has been seriously undermined as a consequence of this case, which was decided on the 11th of September of this year. This also arises out of a more complex factual situation than that which pertained in the bids case. And however, the opportunity was taken by the court to restate the law in this area in a manner which I would suggest to you is of considerable assistance to persons concerned by this area. The carte bleue basically is a system that used to only be national. It's now it's international. It allows international payments as well, but it's a system which was established by the French banks in 1984. And what it did was to allow bank cards issued by the member banks to be used to make payments to all traders affiliated to the carte bleue system through any member bank, and to withdraw cash from ATMs operated by other member banks. Now, the way the market developed after that was that certain member banks expanded their activities as issuers of cards. So the main interest was to get the cards out. And of course, obviously, all these transactions are profitable. Others, however, spent more money affiliating traders with the system and operating ATMs, and they're referred to as acquirers. The perception arose that the issuers were free riding on the acquirers, and or that the CB system was vulnerable to being exploited in that way by new entrants to the market. So they decided to introduce 3 measures, and these measures were notified to the Commission. One of them was a levy, and in effect, the purpose of the levy was to ensure that if you were more of an issuer than an acquirer, you had to pay a levy on your activities. And that levy was paid to the benefit of acquirers in proportion to the amount of acquiring activities they were engaged in. There was a fee per active CB card issued by new members for the first 3 years. In other words, if you arrived along and joined the system post the implementation of these proposals, you were going to have to pay a levy on every new card you issued. And you'll see a supplementary fee for members that tripled the number of cards issued in their 4th to 6 years of membership. In other words, if you come on to the market and decide that you're going to be only an issuer, you had to pay a special levy. And then they had a dormant members charge as well, just to be certain. In other words, certain banks perhaps may not have been very active, but if they were bought out by a larger concern and suddenly became active, there would be a levy on their, let's say, revived or new activities. The Commission decided in 2007 that this constituted a restriction by object, and it relied upon, it said it was evident from the actual formulas envisaged for the activities. It said that the measures didn't encourage acquisition activities because they either imposed additional charges or limited the issuing activities of members. The imposition of supplementary membership and dormant member fees was inconsistent with stimulating acquisition activity, if that was the purpose. If the purpose was to balance up the system, the CB group were going the wrong way about it. And they also relied upon statements that were made by some of the banks to the effect that the real purpose of this was to keep new participants out of the market. The matter was heard at first instance before the General Court, which I sit now. Fortunately, I have nothing to do with this judgment, so I can speak quite frankly. The General Court upheld the decision of the Commission. That was appealed to the court, and Advocate General Wall in March of this year delivered an opinion, and where he made a number of statements of principle that are of particular importance. First of all, the distinction between restrictions by object and by effect is procedural. That's the point I made at the outset. Secondly, the consequences of a finding that conduct constitutes a restriction by object are twofold. One, that the prohibition has a very broad scope and applies irrespective of the effects of the conduct. And secondly, as I pointed out, enforcement authorities can replace proof of anti-competitive effects of conduct by an analytical framework. So on that basis, agreements which are restrictive by object are only those that seem highly likely to have a negative impact on competition without any evaluation of their actual or potential effects. This is important, or potential effects. An assessment of the existence of a restriction by object requires a detailed individual examination of the agreement, as distinguished from an examination of its actual or potential effects. And Advocate General Wall, at paragraph 78 of his opinion, stated the test as whether the Commission had sufficiently established, following a concrete and individual examination of the content, aim, and economic and legal context of which they formed a part, that the measures at issue achieved a degree of harm such as their negative effects on competition could be presumed. The Court of Justice gave judgment. It applied the test stated by Advocate General Wall. That's why I would say paragraph 78 of the judgment of his opinion was worth quoting. The court held that the General Court had erred in finding that the restriction of competition by object must not be interpreted restrictively. One of the problems with the BIDS judgment was that the court, it is a very good judgment, it's very short because of course the facts were very clear. The difficulty was that it left open the possibility, because it was so clear, it didn't go off and deal with some side issues. And the impression was perhaps erroneously created that the restriction of competition by object was not to be interpreted restrictively. And Advocate General Weil and the Court of Justice have now made it clear that restriction by object is to be interpreted restrictively because it has this important consequence for shifting the burden of proof. It is something which is not, therefore, to be applied generally. The General Court held to the opposite conclusion, so the Court of Justice overruled in that regard. The General Court failed to explain how the measures created a restriction of competition by object. I think it's also fair to say that that criticism was equally directed at the Commission's decision, because the Commission also failed to explain how the measures created a restriction of competition. The object of impeding new entrants onto the market itself was insufficient to meet the test, and the object of imposing a financial contribution on issuers for the benefit of acquirers was not by its very nature harmful to the proper functioning of competition. So where does that leave us? Well, I would suggest it leaves us in this situation. The court has, for the benefit of all, restated and clarified the concept of restriction by object. It has limited that to conduct that can be presumed to have a negative impact on competition. So it is where one looks at to some extent, one looks at things slightly in the abstract, not in the abstract and theoretical terms, of course, because one must look at the economic context in which the agreement is being entered into. And you'll see that Advocate General Weil, for example, in his opinion points out that some things that at first glance might be seen as restrictions by object might, in certain contexts, for example, a price-fixing arrangement between parties that have a very small amount of market share, will not be a restriction by object, even though you would think a price-fixing arrangement must by definition be a restriction by object. And finally, restriction by object is determined by reference to not to the nature of the conduct and not by its possible effects. I hope you found that interesting. Thank you for your attention.
Thank you, Judge Collins, and thank you for keeping to the time in such a good way. And now we'll move to